Okay, well now we have our keynote speaker, Jean-Claude Piris. I am going to read his biography out because it is quite long and I couldn't read it. There's only 3 lines, don't worry, it's not so bad. He was legal counsel of the European Council and of the EU Council of Ministers, Director General of the Legal Service of the Council 1988 to 2010, and legal counsel at IGCs leading to the Maastricht, Amsterdam, Nice, Constitutional and Lisbon treaties. He is now going to talk to you until he has to go catch his Eurostar in approximately 25 minutes. So, off we go.
Thank you very much. Is it on here? Okay. So I will be very quick. I'm trying to give you an idea about how I see the negotiations where they are now and the perspectives. Just a remark that the UK government had the opportunity to prepare its plans, to explain that to the public opinion, and to start from that for negotiations, but it did not. So it has lost, and it is still losing a lot of time, and the clock is ticking, as Mr. Barnier said, and there is coming with that some effects, some consequences. Because if you add that it's, for me, politically impossible to prolong the period of Article 50, because not for the reasons which were told this morning, which are equally good, but in the European Union, we have elections in the European Parliament in spring 2019, and it's totally excluded that the European Union and the UK will accept to have a political campaign in the UK and electing. So it's out of the question. So the real question is that when the 30th of March 2019 will arrive, either we have an Article 50 agreement on the divorce settlement, on the debts of the UK to be paid. It's not a bill to have something in exchange. It's only debts to be paid, on problems to be solved on protection of citizens, and so on and so forth. We have this agreement. We have no trade agreement, of course, for the future, because the trade agreements cannot be negotiated, well, signed, let's say, before the UK is effectively a third country to the EU. You cannot sign an agreement with a country which is inside the EU on trade. And you have also to know that the legal base giving the powers to the EU, it's not the same as Article 50. It's other articles of the treaty with other procedures which can be launched only after Brexit. So if you have an agreement on Article 50, you don't have a trade agreement. If you have no agreement on Article 50, of course, you don't have an agreement on trade either. So that means you will have, during a period which some people evaluate 1 year, 2 years, 3 years, some others say 5 years or more, but let's say at least 2 or 3 years, you have a period when you have no trade agreement and you have what is called a cliff edge. That means WTO arrangement. And I will go to that, but it's very bad for the British economy. So you badly need to find a way to wait. And to wait, the only solution is implementing period. According to the UK, we call that a transition period. And on that, I think that the only solution for me is to be very, very, very simple. Because if you begin to negotiate, we have no time to negotiate. So if somebody in the UK says no fisheries or not this, and the EU asks for compensation and so on and so forth, we have not finished. So I call that the full Monty solution. You take all the obligations of the UK, as it is a member now, and you continue to have them, except, of course, that you are already Brexit. You are already outside of the EU, so you have no representation of your nationals in institutions. And I propose that we make an exception to the obligations, is that the UK could negotiate agreements on trade with third countries in this implementing period, in this transition period. So that means that the UK will have also all the benefits it has now and all the duties it has now with its opt-outs, of course, no question to change rules and so on and so forth. I think it's the only solution, and because otherwise you have cliff edge, which means the tariffs from the EU, which on goods on goods it's not very high, 3%, but it's higher on automobiles or part of automobile, and it's very high on some agricultural products, and also same thing with the 70 or 80 countries with which the EU has trade agreements. They will apply tariff against UK products. So, and above all, the UK products coming in the EU, coming from the third state, outside of the internal market, will have to prove effectively that they follow all the norms and standards of the EU. And that will be quite administratively and in practice very, very high. So, but nobody is prepared to the transition period. The public opinion does not know yet it's necessary. And I'm not sure that politically it's possible to sell it both in the UK and in the EU, because in the EU you have some people who say, why giving some more time, and we have so many things to do, and it's not our primary objective, and so on and so forth. So, my opinion is that we will have a transition period, we might have one, if we have an Article 50. It will be very, very late because unfortunately the UK should have asked that from the beginning. They are asking that now without details. So a solution would be, but it will imply goodwill from both sides, to announce maybe as rapidly as in December or in January that we have an agreement on a very simple full Monty period of transition, but of course, nothing is agreed until everything is agreed, and that will be formalized legally when we will have Article 50, but you will give some trust to economic operators. So where are we now on the three subjects? So basically, the withdrawal of the EU is a unilateral decision. So UK came and said, we leave. So the reaction of the EU was, okay, but we have to settle on the basis of the rule of law, as you explained this morning, and that means that Article 50 and Article 50, please, you have to pay your debts before leaving, and you have to tranquilize us that there will be no trouble between Northern and Southern Ireland, and our citizens in our countries will have the same rights as they have now. So where we are now, it was said this morning, well advanced on protection of citizens, remains a few technical problems, reunification of families and so on. Major problems, the Court of Justice, because the EU says, as a matter of principle, the EU Court is doing that for the rights of our citizens. It has to be the same. So. And as a matter of principle, UK says no, it has to be British court and so on. I don't exclude an arrangement, and somebody spoke about that this morning, taking into account and so on and so forth. I don't exclude that. Okay, on the debt, I think we have to have progress on the UK side, admitting a little bit more clearly what are the debts, not figures, because figures, according to me, they arrive only at the very end. But at least progress on the categories of debts, and then negotiations on modalities of calculation. Pension of officials are one thing which is undisputable, I think. Same thing for the decisions taken by the UK with the others and so on. And you deduct if some profits will not go back to the UK on that. So I think we'll have a figure at the end. The only thing is borders of Northern Ireland, and that I agree with Brigitte Laffan, that there is no solution on that, because we need to have a border. simply saying we need to have bordered external borders of the EU. If not, there are frauds. So there will be things on citizens, God says this morning, common travel area, and maybe things which be lighter and so on, but there will be a border. So now the third thing is the framework for future relations. And there, Mrs. May says we need something in between Canada, CETA, the agreement signed by EU with Canada, and EEA. I'm sorry, there is absolutely nothing in between, nothing. Either you are a member of the EU or the EEA, and you implement all present and future laws, or you are not. And if you are not, the best on the market is the agreement with Canada. Why? Because we have to protect, as you said this morning very clearly, internal market. Internal market. People don't know what is internal market. It's a revolution, international law. It's not tariffs and duties. Tariffs and duties, that's a long time. They are not very important in exchanges. It's all the norms and standards. So they must be adopted by the same authority, with the same words, interpreted by the same authority, controlled, sanctions against member states, sanctions, damages to particular individuals if violated, and so on and so forth. That's a condition sine qua non to be accepted by a country to participate to the internal market. If not, not. So EEA, according to me, it's out. I agree. It's impossible for the EU to accept that because politically, to have free movement of persons, to have the duty to implement all laws without participating to the decision, and to have the Court of Justice, it's not politically realistic, even for an interim period. So my conclusion, hesitation between pessimism, because there will not be agreement on the figure because it's so politically visible, on the Court of Justice because it's dogmatic, and nothing on Article 50 and no transition period. That's the cliff edge. It's terrible for the UK economy, terrible, it's a catastrophe, and it's bad for the EU. Or optimism, and I am always optimistic, so an Article 50 agreement. It's possible, it's possible. I think in December we'll pass to the second phase, and a transition period. It will not be, as I said, but you have to launch ideas to be discussed and so on. So for something simple, quickly acceptable, and on this basis, we will have an agreement on future relations to be settled during this transition period, and which will be more or less the agreement with Canada on internal market, plus a series of many other agreements on external security, internal security, Euratom, agencies, programs, and so on and so forth, because the UK and the EU share the same opinion and needs about that. Thank you.